Hi, everyone. Thank you for joining us for Monday night's program. I am happy to have two special guests with us. We are covering coast to coast on COVID-19 with relation to workers' compensation and employment management. With me tonight is Saro Kirkonian, a California-based attorney, licensed attorney, and Scott Onegian from New Jersey, practicing in New Jersey and New York. Saro is a high exposure attorney with Hartsucker, Stratman, and Williams Abrego. He has been practicing for 32 years. He is a founding member of the Armenian Bar Association, former chair and current treasurer. Saro has extensive workers' comp exposure and experience, and he is also the author of the Rudder Group, Paralegal on California Workers' Comp Law. Scott, on the other hand, all the way from the East Coast, is a partner of Riker, Danzig, Scherer, Highland, and Peretti. He is licensed to practice in New Jersey and New York, with the firm having offices in both, if not throughout the nation, and he'll get into more of that. He has formerly clerked with a federal judge, has mainly practiced in employment law management on the employer side, extensive history with litigation, and I cannot be more than thankful to have both attorneys from California to New York to cover what everybody's been waiting for regarding COVID. Good evening, gentlemen. How are you?
Good evening. Good evening, Christina. Doing well. Thank you. Thank you for
having me. Christina. Thank you for having us.
Thank you for joining me. So we are live, and I have a bunch of questions that I want to ask. And before I do want to remind everybody, I'm Christina Malayan from Malayan Law. I do personal injury, catastrophic injury cases, along with estate planning. I am based out of California, Glendale specifically, but I do practice throughout the state. Now, before we get into our program, I do want to remind our viewers that this is just for informational and educational purposes only. We are here to provide you guidance and as much as information as we have collectively put together. However, if you do have specific questions, you can always reach out to me and I can put you in touch with the appropriate counsel. Now, before we get started, Sara, I want you to introduce yourself. Can you please tell our viewers a little bit about you and your background and what, whatever information you want to add?
Okay. Thank you, Christina. As you said, I've been practicing for 32 years. I have presently I'm on the defense side. I represent farmers insurance in defense of their workers' compensation claims. But for 25 years, I also represented the injured worker, the applicant, as they refer to him, and as they refer to the injured party in workers' compensation matters. So I've had experience on both sides. I've served sometimes as a judge pro tem, handling matters, calendar matters, conference matters for the WCAB.
Okay.
And I also have the honor of serving on the California Lawyers Association Workers' Compensation Executive Committee. So I never thought I'd do workers' comp, but 32 years later,
Here you are today with us doing that. So both, you have experience on both ends, both applicants and now current defense, correct?
Yes.
Very nice. And how was it to put together the Rudder Group for the paralegals guidelines?
It was, it's in its fourth year, fourth edition. I do a new edition every year, and it took me over 2 or 3 years to prepare it. I started from scratch and really researched, but that's one of my pride and joys of my career. Yeah, it keeps me abreast of all the new cases and the new laws.
Very nice, very nice. Thank you so much, Sara. Turning over to you, Scott. Thank you so much for taking the time. I know we have a couple of hours of a difference, but thank you so much. Can you please introduce yourself, give us a little background on what you do, and then we'll get right into our questions and our program.
Sure. Thank you, Christina. My name's Scott Onegian, and I'm a partner at Riker, Danzig, Scherer, Highland, and Peretti. We're a 140-year-old full-service New Jersey law firm, and I'm the head of the employment group. We represent management or employers in employment disputes and both in litigated matters. And then we also have a number of employers for whom we do what I like to call litigation avoidance, which is counseling them on their employment practices to ensure that they don't end up as a defendant in a lawsuit. And Sorrow, consistent with what Sorrow said about staying abreast, for the last 2 months I've been back in law school, though it's been in my basement, as I've followed new laws being passed at the state and federal level, executive orders. In my 29 years, we've never been in a legal landscape that's moved as rapidly as we have in the last 8 weeks. And in some ways, it's been a little bit invigorating because you have no choice but to totally immerse yourself in it, or you're going to miss something. And if you miss something, you can't provide appropriate guidance to your clients.
Very interesting. And I know that is why one of the reasons why we collaborated together to put this program together, to educate our audience that it is changing. It is fastly, it's like a chameleon. It's changing from last week's orders were different than this week's orders. And we will get into the specifics of that. So with that said, I do want to begin our conversation. I am, as I mentioned, I'm going to read some live questions. So as they come in, I may interrupt and I may ask questions. So I'm urging our viewers, if you have any questions to ask us, if we have the answers, we'll provide it. If we don't, we'll give you our opinion about it and direct you to the right resources. Scott, you did mention with regards to your involvement and your particular firm, you do provide consultations across the nation?
My practice is primarily in New York and New Jersey, though there are some businesses that are based here that have a presence throughout the United States, and I help them with their employment issues everywhere. My firm is a full service firm, and there are other practice groups that literally practice all over the country, including in California. But someone in New Jersey doesn't dabble in California employment law. It's smart to have a California employment lawyer defend you there.
Absolutely, absolutely. Now, getting to our first line of questions, with regards to workers' comp, I want to know, Sarah, from your end, being on the defense side, what is the hush-hush talks about what is going to happen, and what are the insurance companies anticipating as a new wave of presumptions, or the new wave that's going to hit workers' comp attorneys, both on the applicant side and on the defense side?
Well, in California, as Scott mentioned, there's changes happening all the time with workers' compensation. In fact, last week on May 6th, Governor Newsom issued an order which applies to COVID-19 cases, where he imposed a presumption, a rebuttable presumption, where if a worker is working outside of the house between March 19 and July 5th, and they get diagnosed with the COVID-19 illness, and a doctor, a physician or surgeon diagnoses the condition after March 19, and after the worker has worked at the employer's work site or in the field, then there's going to be this presumption that that illness is an industrial illness, which meaning it happened on the job, which then entitles the applicant to the benefits that California's workers' compensation provides, which I could list those benefits. Number one,
we're going to get to the benefits, okay. But just to make it clear for our audience, well, you're saying March 19 to July 5th. So the employee has to be on the job site, or is it also with regards to remote working? Because if I'm not mistaken, most of us went virtual and remote right as soon as the orders came down to the nation.
Well, so this presumption that Governor Newsom issued is a temporary. It's in effect for 60 days, and it doesn't mean so. For a worker to be eligible for the presumption, they have to have been working outside of the home. But that doesn't mean someone who's at home couldn't try to prove that they got COVID-19 from work. I mean, it's going to be very difficult for them to establish causation, meaning that the link that it is work-related, but they could try to prove it. But the difference is that this presumption that Governor Newsom issued is specific to workers who are working outside of the house, who are, while the economy is getting back into revving up again. I think he wanted to make sure that those workers are protected. And if they do, unfortunately, get the virus and the disease, then they're going to have medical treatment and all the other benefits that workers' comp provides. So, in a nutshell, someone still working at home could still try to prove it. I think it would be very difficult. We'd have to come up with a scenario to imagine that they're working at home and somehow they develop the disease from a work-related condition.
But outside of their home. Okay. So a quick question with regards to some of the facilities or work that you're referring to that they would develop between March 19 to July 5. We're talking about mainly the ones that were considered essential and actually had to go. For example, grocery stores or marketplaces, correct?
Well, those definitely would be part of this presumption. They would be eligible for this presumption, but it's not limited to them only. Now it's open to any worker working outside of the home who's returning back to the workforce and who meet the requirements, which I mentioned earlier. If they can establish those facts, then they'll be eligible for this presumption. And then the burden shifts to the employer to try to show that it wasn't due to work, it was caused by some other source, maybe a relative or some other source. But that's a very heavy burden on the employer then to try to overcome that presumption. Presumptions are very powerful things in law, and once you have a presumption in your favor for the other side to rebut it, it's an uphill battle.
Right. Scott, do you have any insight with regards to New Jersey or New York with relation to any workers' comp or, from your experience and on the management side of employment, do you anticipate any changes and new waves coming through on the East Coast?
Well, I do not do any workers' comp, but there's a similar bill in the New Jersey State Senate, which would create a similar presumption that someone who is going to work, who contracts the virus, there'd be a presumption that was work-related. And the various business groups are very strongly opposing that, as I'm sure they did in California, for a variety of different reasons. But that's, with everything else happening, since it's not within my zone, I'm not focusing on it that closely.
Okay, thank you so much for that. Now, Sarah, back to you. With regards to some of the benefits you were referring to, what are those benefits that you were about to mention?
Sure. Under California law, the primary benefits that an injured worker could receive for an industrial injury, number one is medical treatment, of course. We want workers to get better and get back to work, and so they get medical treatment. If they're unable to work because of their illness or they have to self-quarantine, they'll get what they call temporary disability. That's usually 2/3 of their average weekly earnings, up to a maximum. There's a minimum and a maximum, but they get temporary disability. It could be for up to 2 years if the doctors certify them for that long. And then if they end up having any permanent residual impairment of their future earning capacity, they could be entitled to permanent partial or permanent total disability if their disability precludes all future earnings. And that's a percentage between 1 and 100. I'm giving you a very broad overview of the whole system, but
yeah. So with that said, before we get into the details of what this new presumption and the new orders are going to allow workers to tap into, typically speaking, just for our audience, who can make a workers' comp claim and what is a workers' comp claim? Just basic information.
Yeah, so under California law, we have a no fault system with regard to work injury. So if a worker could prove that they had an injury at work, they call it arising out of employment and during the course of their employment, then they generally are entitled to the benefits of workers' compensation. So the primary thing that the injured worker has to prove is that they had an injury at work. I mean, it could be a delivery driver being involved in an automobile accident. It could be they were going downstairs and fell, but it could also be that they developed illness from an occupational setting. You know, it could be anything from cancer to, you know, even valley fever, that this condition that's in the San Joaquin Valley, there are cases that found a worker who got valley fever was covered for that illness. So there's two types of injuries in California. One is called a specific injury, like an accident, a fall, or an auto accident. And then there's what they call cumulative trauma, something that develops over time.
Yeah, like carpal tunnel syndrome,
Right.
backaches,
Correct.
you know, all the fancy, colorful ones that these applicant side attorneys could come up with.
Correct.
Yes. So we have a question here, and I am trying to see if I could phrase it right or whatnot, but I will read it as they come in. One viewer asked, would an employer try to do cluster tracing to rebut how, where the employee contracted COVID-19?
They could try under the, I'm not sure about cluster tracing, but an employer could, that could be a way. Let's say there's a cluster in the apartment building where the injured worker is working, and and so the employer is going to try to show, well, there was an outbreak at the applicant's home in the apartment building they're working in, and that could have been the source. I mean, if they have enough evidence, let's say nobody else at work had COVID-19 and everyone was tested. Let's have a scenario where everybody was tested, nobody had it, and the applicant lives in an apartment building where there was a severe outbreak of the disease. I mean, if there's enough evidence, medical evidence, factual evidence, there could be a scenario where the employer could rebut the presumption. That's probably why the governor made it a rebuttable presumption versus a conclusive presumption, because they could imagine scenarios where the employer could have enough evidence to overturn the presumption.
Okay, I'm going to move on to Scott. Scott, I want, given your extensive history with working on the federal end and federal acts, we came out with the CARES Act, the government, and I know it's caused a lot of, hopefully some direction, but a lot more confusion. With our previous conversations that we've had earlier throughout the week, we talked about how things are constantly changing. So with that said in mind, I want to talk and let our viewers know regarding what exists currently on the federal level, and then we'll get into the one that the Stimulus Act brought us to. So with that said, I want to know more about the Family and Medical Leave Act, to very general, very basic information, so that our viewers can know who can apply for it. If I have a mom and pop shop with one employee, am I the one who needs to provide it? Or if I'm running a factory with 100 or 200 workers, do I need to provide it? Just basic information on the Family and Leave Act before we get to the Corona Response Act.
That's a big question, Christina.
Well, let's break it down. What is the Family and Medical Leave Act?
Well, the Family and Medical Leave Act has existed for I think since 1993, but I'm not exactly sure of the date. And what that has enabled employees who either suffer a serious health condition or they're caring for someone who does, it has enabled them to take up to 12 weeks away from work and have job protected leave during which their benefits would be continued, but they would not be paid. The difference with regard to the statutes that have been passed within the last 6 weeks is they're providing payment to employees, either because they contract the virus or they're coming down with symptoms, or in the event that they have to care for someone under those circumstances, or because they're home because their child's school has been closed. There are a number of different scenarios that I would bore everyone if I went through. But if someone is thinking about or wants to look into whether or not they might qualify, or even better, if they're an employer and they're curious whether their employees might qualify, the United States Department of Labor's website is an excellent tool that I literally look at least 3 times a day, because at least once a week they've updated their FAQs, or frequently asked questions, and their guidance on all these issues has changed. So
what is that website, Scott? Do you have that offhand?
It's dol.gov, and the Wage and Hour Division is the one who has the answers to many of these questions. But then, and I know you didn't specifically ask about it, but you did mention the CARES Act. Everyone has been reading about and has heard about the Payroll Protection Loan Program. And in that instance, it's actually the Department of the Treasury that's been issuing updated guidance about whether those loans can be forgiven or whether they're going to turn into loans. And what has happened is that the legislature, in the face of an emergency, rushed to pass legislation to address the problem without necessarily considering all the implications that legislation might have. And as time has gone on after the fact, the government has provided us with more guidance as to how those statutes will be interpreted. So
they basically did like a mass release of everything possible under the sun, and then now they're fine-tuning it.
Fine-tuning is the nice way of saying trying to fix problems,
okay,
or correct ambiguities or conflicts or mistakes. But I think we all understand why they did what they did. I mean, we found ourselves in a situation that in 1918, during the Spanish flu, they didn't have Facebook Live or Zoom conferencing. But, no one in a position of authority now had any precedent or any situation that they could look at and say, well, here's how we responded to this, and then respond to COVID-19. We're in truly uncharted waters.
Wow, it is. It truly is. Now, with regards to the Family and Medical Leave Act, is it applicable to every type of employers to provide that type of coverage, or do we need to have specific amount of employees in order to provide this particular benefit?
All right. Well, you caught me if I were in the office, I could yell to the associate next door and say, how many is the minimum? I don't have them all memorized.
But it's not one, right? It's not your mom. It's not a solo practitioner.
No.
Correct?
No, it's not.
Okay.
I think it may be 50, but it could be 25.
Okay.
The Families First Coronavirus Protection Act is employers between 50 and 500. I don't know how many New Jersey people are here, but in New Jersey, the law against discrimination applies when you employ one person. Mm-hmm. So it does apply to everyone. So again, if there's an employee who's listening to this, whether or not your employer is governed by these statutes, that's information that's easily accessible on the Department of Labor website.
Perfect. And I did check it, Scott, you are right. It is 50 or more employees in the last 20 weeks of the last year. So let's get to the Families First Coronavirus Response Act. And this is huge, right? It's pretty much a little bit of an extension of the Family and Medical Leave Act. When are the effective dates? When does this act provide coverage for?
April 1st through December 31st of this year.
Okay, and what changes or additions or substitutions did they extend with regards to this act?
Okay, well, as I mentioned earlier, the Family and Medical Leave Act allowed an employee to be out up to 12 weeks during a 12-month period and keep their job. But it didn't require the employer to pay them anything.
Okay, so now the employer has to pay?
The Families First Act allows for payment if someone is sick for up to 80 hours, and then allows for up to another 10 weeks of a reduced benefit. So it's a significantly more rich program for employees who take leave under the statute than the existing family leave at the federal level. Some states, I think California does have and already had some paid family leave, but most jurisdictions do not. So it goes from just being a job-protected leave to one in which an employee can stay home and get paid. Though just like Saro said before, there are caps on that. Someone who makes $200,000 a year is not going to receive her full salary. It's capped out at a certain level, but for more lower level paid employees, they can receive the same as what they were receiving if they were working.
I have a question coming in, and one person's asking if your employer can ask for documentation with regards to the Families First Coronavirus Response Act, whether or not you've been diagnosed or have to take care of your child. So before we answer that question, what circumstances warrant one to be exposed to this benefit?
Well, there are different scenarios. One is if I'm sick myself, or if I'm symptomatic and I need to see a physician, or I've been ordered to quarantine. Under those circumstances, I'm eligible for the paid benefit because I myself am sick. But then there are also circumstances where it's in a different part of the statute where someone can be eligible for payment if they have to care for a family member who's been diagnosed or ordered to quarantine, or they have to stay home because their child's school has been closed, or if they're part of a lockdown where they're not allowed to leave even though they may not be sick. The benefit is greater to someone who's actually sick than it is to someone who's just taking care of someone else.
When you say the benefit, you mean the monetary amount that one's going to get?
Yes. Okay,
so it's not similar or the same across the board. It's very individual specific.
Yeah, that's also, and I'll send the people back to the dol.gov website. They actually have a couple of very helpful posters that are easy to understand. There's a lot more detail than that, but it goes through the 6 different scenarios where one could be eligible or not. And then many states also have their own counterpart emergency measures that have been taken over the course of the last 6 weeks. So someone who's looking to protect their work site from an employer standpoint, or an employee who feels that they might be eligible to receive various benefits, they shouldn't just look to the federal law. They should look to the state in which they work as well.
Right.
And the state in which they work, not where they live.
the working state. Yeah, Scott, you mentioned the three things. I do want to break it down and address each one. You mentioned that, I'm actually going to get to the second point. You said you can actually tap into this act and get benefits if a member of your family has been diagnosed or required to quarantine. How is that going to play along with some HIPAA violations? Like, is my employer going to be able to ask me for proof if my mom is sick and I need to stay home? Do they have the right to do that? And as an employee, do I have to give that to them?
Yes, but the employer also has a duty to safeguard that. Just because the employer has the ability to request information doesn't mean that the employer can therefore disseminate it among its workforce. You know, the same, shifting gears a little bit, I know you didn't ask me this question, but as we're hopefully preparing to get back to the office or to go back to work, you know, we're putting plans in place to how do we reopen the workplace. And one of the recommended steps is that we take people's temperatures before we allow them to access our facility. And the EEOC, also part of the Department of Labor, has issued recent guidance which would permit an employer under these circumstances to administer a medical test as a precondition to allowing people onto the work site. You know, before that guidance came out, that would ordinarily be something that an employer would be prohibited from doing. So, you know, what the government is doing is it's trying to balance, you know, the rights and protections of individuals with a business's ability to do business, and then also the well-being, excuse me, of all the other employees. So you don't want to have a sick person coming into an office and infecting 50 other people. So
talk about a workers' comp case over there.
Exactly.
Yeah. Oh, huge. If not negligence or any personal exposure on that end. Definitely, I'm going to bring up the topic of the personal protective equipment and all those gears, and on both ends, what both of you are going to recommend. So, Sarah, turning it over to you, kind of as a follow-up to Scott's, mentioning of taking temperatures. Do you anticipate the workforce changing, the workplace changing? Do you anticipate any new measures taking place in order to avoid some workers' comp issues? What would you recommend as a general good business practice for employers?
Yes, I do anticipate quite extensive changes going forward in the immediate future, but even long term, it only makes good business sense. You want a healthy workforce, right? Your workers are what are the engine of your business. So of course, it's in the best interests of every employer to have a healthy and well workforce. So I recommend, especially in light of the presumption that Governor Newsom has enacted or has ordered, that every employer should do their utmost to make sure that their employees have all of the protective gear that they can have. To make sure, to try as best as possible to mitigate the risk of developing the virus or contracting the virus and the disease. And there are a lot of guidelines for each industry, in different industries. The County of Los Angeles, the Cal OSHA, and different agencies have developed guidelines for, and the CDC, of course, they've all developed guidelines for employers to follow. It would make total reasonable sense to follow those guidelines, implement them as best they can so that their business isn't impacted, so their workers are healthy, they can have a thriving business during this difficult time, and avoid having a very costly workers' compensation outbreak at their workplace. If the unfortunate thing happened and some employees started developing the condition, it could be costly for employers. So I totally recommend following all the guidelines, and there's resources just like Scott was referring to the Department of Labor. There's in California, there's the Department of Industrial Relations website. There's the County of LA Public Health Department website. There's Cal OSHA. All of these are great resources where an employer can look to see what they can do to protect their employees.
Scott, yeah.
So there's another, and I willingly admit I come to this from the business management side. There's another reason. You know, I have a nice corner office 30 miles away that has been empty for 2 months, but I've been very efficient working here in my basement, and I'm not sick, and I'm not getting anyone else sick, and no one's getting me sick. I think a lot of businesses will look carefully at themselves and do a little self-critical analysis and say, who is productive, who has remained productive, who's even more productive working remotely than they were when we required them to take mass transportation or commute for an hour. And you know, before we got into COVID-19 world, one of the questions that I had to answer my management clients all the time was, so-and-so says they have a disability and they want to work remotely. I say no. It's an essential function of the job that you come to the office every single day and that you're available in the office at least 12 hours a day. And we used to once in a while be able to win on that argument. But with the way we've functioned for the last 2 months, it's going to be a lot harder for an employer to demonstrate that it's an essential function of the job for an individual to be in the office from 8 a.m. to 6 p.m. every day of the week.
So you find yourself having these conversations with those that you provide guidance on the employment management side?
Yes.
Yeah.
What I'm saying is that's going to change. That, you know, and even now when we get to the return to work time, if there's someone who's in a high risk group, either because of their elderly or they have one of the, what they talk about, Governor Cuomo and talks about all the time, comorbidity functions, or, you know, someone who's sick, and they say, I know the office is reopened, but I don't want to go back because I have X, and I'm concerned about exposure. You know, there are going to be some difficult conversations from a business standpoint in determining who can be required to return to the office or factory or warehouse and who's able to do their job from home. Now, if they can't do it from home, that's a different discussion.
Right.
So, you know, I'm sorry, go ahead.
No, go ahead. I was going to ask you, you know, what would be those circumstances that they can't do it from home?
The person in the mailroom who pushes the little cart around the office. Now, I guess they could scan things in the office and email them to someone. But there are functions that actually do require that someone physically be located in a specific place.
Right.
How about a file clerk in a law office?
Right. It's very interesting. I think a lot of this, like you mentioned earlier and during our conversation, businesses are going to do a self-awareness and a self-auditing to see what can be replaced, what should be replaced, and what needs to be in place. Now, we are getting questions. We're getting a lot of questions, so I want to interrupt that flow, but I do want to ask the questions. Somebody asked, if someone working from home they don't contract the virus, but they contracted from a family member who is considered an essential worker, hypothetically speaking, maybe a nurse, a doctor, because they're the ones with high exposure. Will they qualify, or can they open up a workers' comp case? Because they are working from home, they are remote, and that is their work environment with the terms that we speak of today.
Yeah, that's a great question. I mean, it could, right, if they were required to stay at home and work at home, that is their work environment. And if they develop the injury on the job, let's say they were typing and working their usual day, they're clocked in, and that is a scenario. I mean, there's no case yet on directly on point, but that could be a potential scenario where the worker they wouldn't be entitled to the presumption, because the presumption applies to people working outside their home, but they could prove it under the regular law that already exists, that they developed this illness while on the job performing their arising out of and during the course of their employment.
It's kind of like the going and coming to from work or on the job, like you mentioned earlier. Question, how do you expect COVID-related cases to impact employer ratings with workers' compensation carriers? Open to either of you.
I mean, I'm not an underwriter. I'm not involved in that part of the workers' comp field, but could it affect? I mean, potentially, yes, it could affect if there was a outbreak at a factory, or let's say a meat packing plant, and it could affect the premium. Yeah, it could. But again, I'm not a underwriter. I'm not involved in that process, so I couldn't give you an exact answer. I don't know if Scott, you could have.
Scott, are you having any of those conversations with your with your clients on the business end with regards to facing higher premiums, possibly if we do get an outbreak of workers' comp cases?
You know, the Department of Insurance regulates premium, and so insurers could apply and ask for a rate increase, but it's subject to government oversight. So it's a very involved process. So it could happen, but there would be protections for employers, and employers would have a say in whether there should be a premium increase or not, or the rating factor should be increased. Again, I'm not an expert in that. It's not part of my daily work. It's a whole different department that takes care of that. And but I know in general there's a process that goes through. It's not such a easy process to do, but it could potentially, if there was a severe outbreak, and that could happen.
Yeah, and that's where probably attorneys like Scott come into play, where they advise their businesses and on the employment management, and where they take precautionary measures prior to getting to that level. Correct?
And that's what we're trying to do now, is prepare. What can we do when we do reopen, so that we're providing the safest work atmosphere possible, A, to protect the safety of our employees, and B, so that we can't get sued, so that we can show that we took the steps that, to comply with the CDC guidelines and whatever local and federal guidelines might have been in place to make sure that we protected folks.
Got it. Scott, you mentioned earlier with regards to the Families First Coronavirus Response Act that possibly if you're within the category of having your children stay home because of school and you have to watch over them. Now with summer coming up and summer school coming up, what are your thoughts about that? During that period, do you anticipate people qualifying or receiving benefits under the act?
It's interesting you raised that, because the Department of Labor actually updated its FAQs today, and one of the questions related to an employee who had been working from home since mid-March. That employee's child had been home since mid-March, and that employee has been working. Now the employee says, oh, by the way, I don't want to work anymore. My child's home. I have to take care of them. I want the benefit under the statute. And again, I'm going to show my bent as a management side employment lawyer. To me, that's ridiculous. But the Department of Labor says that person is eligible to receive benefits, stay home and do no work, and get paid by the federal government. However, schools end in the not too distant future in most states around the country. So once your child's school was scheduled to end anyway, you can no longer say as an employee, I have to stay home and take care of my child because the school was ordered to be closed. Now that person is in a situation that they would have been in anyway, absent COVID. How does my child get cared for once school is over? So their benefit would end presumably the day after school was scheduled to end for the year.
Okay, but if they resume back to school and they haven't tapped out of their maximum weeks of benefit, can an employee reapply for that? Should that be the case? Essentially meaning, is it a consecutive 12-week period, or could it be tacked on up to 12 weeks?
The benefit under the Act is between April 1 and the end of the year. So if they received 4, 5, 6 weeks now, and God forbid we're still on lockdown in September, they could receive it again then. But we're going to have bigger problems than that if we're still locked down in September.
Very nice. With regards to some of the stimulus conversation we've had with the CARES Act, I know some people have questioned whether or not the stimulus checks apply, the $600 benefit apply to anyone receiving unemployment prior to the act. What are your thoughts about that?
You mean the checks that the government just sent out to people?
No, so let me give an example. If somebody was unemployed since December of last year, 2019, and their unemployment continues for 6 months, let's say in California, and they did not receive the $600 stimulus, the $600 federal portion of it, can they get that during this the term that they were getting unemployment, or is it specific to when the act passed?
I don't think they can, because the reason for the end of their employment had nothing to do with the pandemic.
Okay. And if it does, and if they were unemployed, it's because of the pandemic that the $600 is available, correct?
That's right.
Okay.
For up to 8 weeks.
For up to 8 weeks, right. Now, Sarah, you mentioned something about Cal OSHA. Very briefly, what is Cal OSHA, and who should know about Cal OSHA?
Okay, sure. So in California, there are regulations that govern the safety of virtually every industry across the economy, from agriculture to mining to even amusement parks, have regulations. And so in general, Cal OSHA enforces those safety regulations and safety orders that the state has adopted for the various industries. Mm-hmm. And so if there's a complaint made to Cal OSHA that an employer wasn't following those regulations, then Cal OSHA could investigate, they could impose penalties, they can hold hearings, they have a wide enforcement authority to make sure that the safety regulations and safety orders are complied with. So that's an overview of what Cal OSHA does.
So now, with relation to Cal OSHA and people who are considered highly essential, like our nurses and doctors and hospitals and facilities, do you anticipate any actions having taken place?
Sure. I mean, for example, yesterday I was just reading the LA Times. There was a very heartbreaking article about a nurse at a local hospital, and there was a COVID-19 patient, and the patient suddenly stopped breathing, and she rushed in to resuscitate him, and she only had a surgical mask, not the N95 mask or respirator or some more sophisticated mask. And unfortunately, the nurse got COVID-19 and then she passed away. It was a very heartbreaking story to read. Well, I read in the article that I guess the other nurses or there was a complaint made to Cal OSHA. And so I'm sure Cal OSHA is going to investigate. And in fact, employers, when there is a death on the job or a very serious injury like an amputation, the employer themselves are supposed to report it to Cal OSHA, and then Cal OSHA will decide whether they want to investigate and determine if there was a safety order violated or not. So again, like I said, like we spoke about earlier today, there are a number of resources that provide the guidelines that employers should follow, especially in the healthcare industry, healthcare system. And it's really important that the employers follow those guidelines that the state has issued, or the county, or the CDC at the federal level, and to make sure that they don't run into trouble like this very sad and unfortunate situation. This heroic nurse lost her life, and
it's truly sad. It's definitely sad. They're putting their life on the lines and coming across this and doing it all for us. And whether or not, whatever spectrum we're on, things are happening and we should be careful. So yeah, it is very sad. I do have some questions. Let me see, if we can get some answers. Somebody's asking that if an employer insists on having employees work from the office when you want to work from home for safety concerns and the employee gets infected, can the employer be held liable? So I think we covered this a little, but just a short recap on that.
Yes, if the employer, it's not so much that they insisted to come to the office, it's the fact that they developed the condition at work. If the employee can prove that they developed the condition at work, and especially now with the presumption, it makes it much easier for the employee to prove that if they have to go to the office to work, and they can show that they developed the condition, a physician diagnoses it, then they're going to be covered under workers' comp. So,
right.
Yeah. Remember, it's a no-fault system. It doesn't, the employer, like the sort of the premise of the question was like, well, the employer forced me. The court's not going to be concerned about fault. They're going to be concerned about, did this worker develop the condition during the course of their employment, and did it arise out of their employment? And with the presumption that the governor just issued, it makes it much easier for the employee to show that.
So I have a question for you, Scott. Questions coming in. Given Scott's experience with employment management, does he anticipate extensive training for HRs, and what changes, if any?
Will the employer-employee relationship be different going forward than it was on March 15th? For the short term, absolutely. I think remote work will become more common. But again, we talked about earlier, remote work, a business is still a business, so it employs people who are productive that enable the business to continue functioning. And
okay.
If it's great to say an employer should continue to pay all of its employees, but if that employer is getting zero revenue, it has no money to pay its employees. So now it has to make difficult decisions, which employees do we absolutely have to keep, so that if we can survive this downturn, we'll still have a business. Because if it just goes out of business, now everyone's out of work. So
The business owners should be training their HR consultants or whoever they deal on the HR end to provide these new guidelines and measures that are coming down and changing on a weekly basis.
Or they should hire a competent employment lawyer to help them through this morass.
Oh, absolutely. Well, yes, absolutely. Employment lawyers will take you a long way. If I haven't said this before in any previous program, if you think hiring a good attorney is bad or costly, wait till you hire a bad one. So I completely agree. Definitely secure up and hire the right people when you need any consultations, and make sure that you have your ducks in a row so that you're not paying the higher price at the end. Absolutely. Let me see more questions coming in, or actually more comments. Somebody said HR needs to be on top of their game, vigilant, safely minded, so on and so forth. Let me see. I asked couple more, most of these questions I've asked. I know, Scott, you mentioned something about the SBA loans and the PPP. What were you talking about that? Can you elaborate a little bit more on that discussion?
Well, the PPP loans enabled a business to borrow money and then have the amount of the loan forgiven if they used it for permissible purposes, namely paying salaries and benefits of employees who made $100,000 or less.
Okay.
And if those people are still on the payroll as of June 30th, this is not capable of a 30-second explanation, but if those people are still on the payroll as of June 30th, the bulk of that loan can be forgiven. So in essence, it's a gift. So what the thought process is that the government will give this money to these small employers who will then give it to their employees, including employees who literally are doing nothing. They're home. But they'll continue to be paid by their employer instead of being furloughed or laid off or have their hours cut or something else, which will also enable those employees to continue to have health benefits through their employer. But it's not a simple analysis, and the government has moved the goalposts multiple times already in terms of how the money can be used and whether it would be forgiven and what the tax impact were. So for small businesses, there's a lot to be considered. And if anyone is watching this who owns a small business, you really do need to consult with your accountant and your attorney to make sure you don't get burned. Because it may actually be better to just lay people off as opposed to getting a loan, which turns into a big noose around your neck when you're paying people who aren't doing any work and you're still not generating any revenue. So if that just increases your debt load, it might put you in a worse position. But it's a detailed business analysis with a lot of different considerations.
Right. Do either of you do any nonprofit work for nonprofit organizations?
Yes.
So there's a question coming in. If you know the answer, great. If not, we could move on to the next question. If someone that is volunteering for a nonprofit and contracts the virus, can the nonprofit be held liable?
Can a volunteer at a nonprofit bring a comp claim, Sorrow? I don't know that.
Usually volunteers are not covered. If they're not an employee. There has to, like, the first element of a workers' compensation case is that there has to be the establishment of an employer-employee relationship. So there's statutes that concern whether some volunteers are covered, some aren't. It depends on what type of volunteer. It's specified.
Is compensation a component? Is a form of compensation in a nonprofit a component?
Well, compensation is a factor in establishing an employer-employee relationship. So that would change things depending on what the compensation package is or what the compensation agreement is. So you have to look at each case on its facts, but compensation would mean more than that the person's not a volunteer. They're actually getting paid for their work, their services.
Okay, very nice. I do have a question here. I don't know if it's related to today's topic. I will read it out loud. If we can chime in as attorneys globally, we can. If not, I can definitely answer Mr. Todd separately. He says, what changes can you see happening in the legal field? Do you expect to see a break in the old-time system of lawyers sitting in large offices, or do you see law firms going to remote work, especially for things that are time-consuming, such as research, drafting, and discovery work? Great question, Christopher. And I know I'm a solo practitioner, but Scott is with a large firm. Scott, any insight on that? I know you touched upon it briefly in the beginning. Maybe we just talk about it again. What do you think is going to happen with large law firms?
I think that's a phenomenal question, and I think there are strong disagreements among people in management positions on that. In my opinion, I think that leaner organizations will be more prepared to be successful in the future. Organizations that invest more in technology and less in real estate and leases. But you know what? There's still no substitute once we have a vaccine and we don't have to wear masks to sitting in the same room with people and collaborating. And while it's great to see you on the Zoom, sitting in a room and shaking hands when we're allowed to do that again, to me, there's no substitute for that. The legal profession has lots of different flavors, but my favorite attorney-client relationships are ones that don't even feel like an attorney-client relationship anymore. It's trust and respect, and that's been earned over many years, and that doesn't happen online, remote. There's a certain personal element.
There's that personal touch to it. And there's as much as, and for our folks, the three of us connected via Zoom recently, and we learned of one another. And even though I feel like it has brought me closer to professionals and colleagues and individuals that I probably it would have taken me forever to meet. I am blessed for that. But like Scott said, there's something about that being personable, being together in the same room, that warmth and, connecting on a different level, which it's hard to do on over the internet.
Particularly when it's three Armenians, Christina.
Yes. So yes, we are three Armenians. By the way, I forgot to announce that. And thanks so much for reminding me. This is my first all-panel Armenian panel hosted program. So I'm very excited. We'll get into that a little bit more. Let me see. Very informative. Any of you available to consult, represent my company on these topics? So we have a question from presumably a business owner or someone that works for it. I will direct him both your ways on the workers' comp and the employment management. I know, Scott, you mentioned California is very particular, but who knows? If there's something you can help, I'll send them your way. If not, you let me know and I'll put Mr. Artinian with the right people. Somebody's asking, I'm a builder and I have hired 40 subcontractors. Which loan program is best suitable for me?
I don't know.
Yeah, so with regards to the loan programs, it's very specific. The SBA.gov website has that information. Should it be even available right now? Because we did run out, right, Scott? We ran out of funds.
It was refunded. I think they're accepting loans again, but stocks them is much smaller than it was in the first round.
Yeah, and I think I heard or read something that whoever's in queue or has applied is being addressed first to, as opposed to new applicants.
I don't know.
Yeah. Okay. So I think that's about it. Let me see with regards to questions. Any closing remarks, Sarah, regarding workers' comp? What should employees and employers know to take away?
Well, this is, historically, there was a Supreme Court case about 22 years ago that dealt with cases where, like, for example, they tackled the question, well, if somebody gets the flu at work, could that be considered a work injury? And the court at that time said that that the employer had to put the person in a position where they were more at risk than the general public, and there had to be a human instrumentality that brought on the condition. But now we're in, a new uncharted territory. As I mentioned earlier, it's really important. The laws are changing daily or sometimes, weekly. And so it's very important that the employers and employees follow all the guidelines that the state and local agencies are giving, just for their own health, but also to promote their business success. And by the way, just to answer the question a few moments ago, the California Workers' Compensation Courts, they are holding hearings remotely. I do foresee changes. We have conferences on phone. They're even going to have trials. They've already had some trials, a few last week. So there are changes, but we'll see if they're going to be permanent. But I thank you, Christina, for your time and for inviting us tonight to have this event.
My pleasure, my pleasure. Scott, any final remarks on the business management and any closing thoughts?
I feel like I've been swinging at moving targets since the middle of March. And in some ways, I don't want to say it's fun, but there are so many questions right now to which there are no right answers. So my advice has been, let's do what's right. Let's do what we can do to protect our people, to protect our business, to protect our customers. And that way, if some unscrupulous plaintiff's personal injury attorney were to bring a lawsuit against us later, we'll be able to show this is the situation we were in. We had nothing we could look to for any guidance. These are the options we considered, and this is why we chose to do this, because we protected our employees, we protected our business, we protected our families, and we did what we felt was right without having the ability to look at anything else.
And
so it's do unto others.
Right, and set precedent and just do the right thing, like Scott said. And I think that answers the last question that did come in, like, counselors, what do you do to stay current given the laws and statutes that are changing so rapidly? And it is the very moment that you follow up, go to these websites, go to CDC website, go to the Department of Labor's website, stay on top of it, do whatever you can, educate yourself. Nobody has the answers now. And like Scott said, we are in uncharted territory. So we are doing the best. And yes, of course, things are going to come up. Lawsuits are going to come up. I mean, that's the nature of the game, but we are doing our best. And most importantly, we are looking out for humankind. So with that said, gentlemen, I thank you for your time and your knowledge and your experience. I truly appreciate taking the time to cover this from coast to coast and joining me for tonight's program.
Thank you.
Thank you, Christina.
Thank you so much.
Thank you, viewers. I do appreciate everybody tuning in. I will have my other guests on Thursday night. We will be discussing, hopefully if the program goes through, the CARES Act and the defenses that are going to be necessitated by possible fraudulent applications and people who applied and received the loan. So stay tuned, and I will have my flyer go up tonight, if not sooner. Good evening and have a great night.